just hearing this case below. Here it is a part-hard matter below. It was fixed for 215. It's the most unfortunate incident. Sijit Chaudhary, my friend Sijit Chaudhary is there. Today, at 12:50 itself, his own younger cousin brother has died in Kolkata. So he has immediately left court and that is the let it be on Monday. He will have
on Monday.
On
sure?
Yes.
After next week we will make
Monday.
Monday थोड़ा सा बाहर रहेंगे.
हाँ?
सकते हैं देरी हो जाए इसलिए.
क्या चीज?
Monday थोड़ा सा बाहर रहेंगे. Thursday अगर हो जाता है Tuesday भी हो सकता है.
Tuesday.
Same position at 250.
At the request of the counsel for the petitioner, appellants. Pose this case on Tuesday.
Problem.
One matter out of the list. This is arising out of land preference case number. I was not sharer उसमें बनाया नहीं कि the award has been passed and now the executing court had directed the respondent to disburse to get the amount from the state bank.
File your objection.
Yes, in the LR case we filed that we are also the sharer in this land acquisition case. The award that has been passed, our claim was rejected.
Notice has been issued.
No, this is fresh.
Is it time barred?
No.
Case number has been given.
Filing number.
Filing number नहीं आप डिफेक्ट पहले लिखो. Defective petition यहाँ सब मेंशन कर देते हैं उसके बाद बस ये कोड बन जाता है लॉजिमा कोड. You remove the defects. You remove the defects and mention. Sorry?
Stamp reporting अभी होगा नहीं लॉजिमा तुरंत ही कर देंगे.
हम यहाँ स्टैम्प रिपोर्टिंग नहीं
नहीं.
करेंगे. मैं आप जाइए.
From the supplementary list, partner case under heading for hearing item 2 WPL 683 of 2015.
Just where is Madam Pal? Inform का क्या मतलब है? I'll dismiss it. What is this? First case she is not here. The court starts officially at 2:15. उनको खबर करिए 6 बजे तक भी सुनेंगे. हाँ बोल दीजिएगा ये. शाम को 6 बजे तक भी सुनेंगे आज. बस आज से ये केस कल नहीं होगा. हम फाइल पढ़े हैं दोबारा नहीं पढ़ेंगे. I've had enough.
Supplementary list and heading for final disposal item 1 second appeal 556 of 2004.
It's a plain written statement.
Yes.
इनका लाउड स्पीकर ऑन करें. क्या हुआ? टाइम के बाद टाइम मिलेंगे. 9 पास ओवर होगा. आप बैठ जाइए इनका आर्गुमेंट सुनिए. Who is going to argue on your behalf? हाँ? Mridula? ठाकुर. She was absent yesterday. आप तैयार हो जाइए. आपको बहस करना है. ये सब चीज़ के लिए टाइम नहीं दे सकते. You have to argue your case. You want adjournment?
Yes.
1 lakh रुपए cost लगाएंगे right now. If you want adjournment, 1 lakh rupees cost. She has come to the court.
No.
We are not going to adjourn the cases like that. Without cost, we are not going to adjourn it. नहीं करेंगे हम adjourn. Suit of 1975. आपका जन्म हो गया था 75 में? नहीं हुआ था ना? आपके जन्म के पहले का सूट. I will adjourn with cost. 1 लाख तो ज़्यादा बोल दिए, लेकिन हाँ sufficient cost तो जरूर होगी. छोड़ दीजिए, आप बहस करिए, आप इनका सबमिशन रिकॉर्ड करिए, उनको बोल दीजिए ऑनलाइन ज्वाइन करने, नहीं तो हम आप ही को सुनेंगे. फाइल क्या आपका? हाँ, कोई बात नहीं, इनको आर्ग्यू करेंगे. प्लीज. Order dated 7/5/09.
The net courts correctly appreciated the judgment passed with that is 125 of 60. That is given to raise other substantial issue. It is involved by the bench. Short facts of this case is that this appellant was plaintiff before the trial. He instituted a suit for declaration of title and confirmation of position of bodies. Prior to that, the prayer to Rashid was to set aside some revenue order passed by a revenue court, by virtue of which eviction orders were passed. But by way of amendment, this prayer was amended. And the suit was heard for declaration of title and confirmation of position. The trial court has dismissed this suit. Appellate court has also heard the form.
The order of this deputy commissioner and Bals and revenue miscellaneous appeal was under challenge.
No, that wasn't, because that was the cause of action.
Right.
That was the cause of action for us.
But that was deleted.
That was deleted. That was deleted.
So what remained was declaration of title and confirmation of possession.
Learned appellate court had given only written possession, but that is not correct. This appears to be a very cryptic order. Appears to be no point of determination under order 51, etc. Nothing like that. And just so that the order has been formed.
Let us see the relief rate.
Our case, let me.
You see, it was that on such deletion.
Deletion. It was deleted.
The title of the plaintiff over the suit land we declared and their possession.
Yes, but the both
confirmed.
confirmation. And Malad, we are today even Malad, today we are in our specific case that Malad, the suit land which has been detailed in the schedule. It was Malad recorded in the name of Malad Sheikh Sanjo, Sheikh Panihal, Sheikh Kamruddin. Sheikh Sanjo, Sheikh Fanyan, Sheikh Karo, and Sheikh Abdul. They were the recorded tenants.
Where is it mentioned in the plaint?
Plenty it is mentioned. The Lord may kindly see, let's Baraman Lashik, it details what that 10 bigas, 14 kathar, 1 dul of Jamabandi land pertaining to Jamabandi number 51. With a large number of lots situated in village Maria, P.S. Magama, subdivision in Voda, stand recorded in the last settlement in the names of Sanjo, Bunyad, Shamluddin, Sheikh Karu, and Sheikh Abdul. This is given in the Palawan. So,
Just a moment, sorry. Have you taken dictation in the first half? Anticipatory beat का जो 2 बैच चल रहा था पार्ट में डिक्टेशन आप जाइए इसको टाइप करिए इन लोगों को बोलिए कि जिसने भी डिक्टेशन दिया है सब टाइप करके कंसोलिडेट करके उनको 5 बजे चाहिए उनको लिखवाना है.
first para length of the plaint itself says that the recorded tenants in some of the plots were and this should be somewhere in this other place. Thereafter, the further case was that the recorded tenants were partitioned the land amicably and they came in separate possession of their respective land.
No, it was the case that some of the property was in separate possession, some was in joint possession.
So far as the property in question is concerned, Lord, it belongs to sex unknown. That is what is agreed. And Lord, he had one son, Sheikh Shedi, and a daughter, Rafini. Lord, after his death, Lord, they succeed. Lord, Bibi Gafina was married to recorded tenant Sheikh.
The recorded tenant is Sheikh Sanjo.
One of the recorded tenants.
One of the recorded
Yes.
tenant. But he's not the only recorded
Not
tenant.
only. But the
You
property
have said
says
so that there are 1, 2, 3, 4, 5 recorded tenants.
there are other.
Others also?
Five. What-
5.
Yes. Further case shall assist that Bibi Gafina was married to Sheikh recorded tenant Sheikh Abdul.
Say?
Sheikh Abdul. He was
Bibi
also one of the recorded tenants.
Bibi
Gafina, daughter of Sheikh Sanj. But he died leaving behind the widow and 2 daughters, Bibi Jaitu and Bibi Kari. And they inherited the property of Sheikh Abdul. And thereafter, after partition, this property ownership as per the plan, but it was allotted to Sheikh Chedi, Rafina and Bibi Jaitu, and they were in possession of it. But as because loss of love and bullock, the land could not be cultivated. And a Urfanama, way back in 15th of May 1948, they gave it to the plaintiff, Jari. So
who gave you the, who executed the Kurfana?
these all these names I have examined.
All these
Yeah,
5 persons.
Three names. One was Sheikh Chedi, another is Mosma Safina, and Bibi Jai.
These 3 persons.
These three. Exhibit 2, Your Lordship.
Sheikh
Irfan.
Chaedi, son of Sheikh
Chedi is son of Sheikh Sanjo.
Sancho.
Mosmat Gafina is wife of Abdul.
Gafina, wife of
And she is the daughter, she is the sister of Sheikh Sanjo.
and sister of Sanju or daughter of Sanju?
It appears one of daughter means daughter. And the daughter means sister.
Gafina was married with Sheikh Abdul.
Abdul was the husband.
How is Gafina related to Sanju?
It appears she was daughter as well.
Yes,
Because Sanjo-
she was the
Sanjo-
daughter.
Sanjo said
She, Gafina was wife of Abdul and daughter of Sanju.
yes.
Sanju. So Gafina was a party to the Khutbah.
Yes.
Sheikh Chedi was the party.
Yes.
And who is the third one?
Third one is Rashid Jaitun, Bibi Jaitun.
And what about Bibi Kadi? Bibi Kadi was also a party.
No, she appears, does not appears to be in the
Two
Kufa.
daughters, Bibi Jaitun and Bibi Kadi.
Bibi,
And a widow, Bibi Gafina.
Bibi Gafina, Mosmat Gafina, Jose Sheikh Abdul, Sheikh Dr. Sanju Bibi, or Bibi
So
Jaitun.
they claim to be the inheritors of property of Sheikh Abdul.
Sheikh Abdul Sanju, who was the recorded, and Abdul was also recorded.
He was the recorded tenant. So the property which belonged to Sheikh Abdul,
Abdul.
they claim to be the descendant.
After partition. That
After
is what it
partition.
is named. It is what it is.
Partition kind of no basic dates have been given. Nothing is.
But these are the factual foundation. These are the factual foundation. Our claim, Your Lordship, our specific claim is that by virtue of Urfana, we came in position of, and I had gone through the Urfana, exhibit 2 is the on record, and Hindi translation.
Unregistered. Must be unregistered.
Urfanama is unregistered. But it is then Hindi translation is also real. Hindi translation is also
Dated 15/5.
1948. Then followed the further case of the plaintiff position. That followed Bibi Gafina, but she is suited a Bhubut Bandha in the year 1962, 9th of April 1962, in favor of one Ram Nagina Bhagat, in respect of plot number 153, 156, 167. But as the plaintiff was coming in position
On when did she execute?
9th of April 1962,
In favor of
one Ram Nagina. Then followed the further case solution. That followed as because this plaintiff was in the position, Sheikh Zari Ali was in the position. So followed they could not take back, position could not be taken, followed, and after receiving money from the plaintiff, the document was returned to the plaintiff. That Bhuput Bada has been brought on record by us. That is the exhibit, Your Lordship. It is exhibit 3. Original Bhuput Bada has been brought.
exhibit?
Exhibit 3 and endorsement on signature is exhibit 4.
Where have you stated so in your claim that you wrote this document?
Late.
Yes.
Late color
BB
Paranai.
Gavina executed
Paranai.
in favor of Ram Nagina Bhagat in respect of plot number, but the plaintiff was coming in possession, refused to allow Ram Nagina Bhagat to get possession. He decided to take back his money from the plaintiff and to return the document to him. And the plaintiff are not the family members of Gafina. The Bukut Banga was executed by BB Gafina. They, instead of returning it to her, they gave it to the plaintiff.
And because possession, I was in possession.
That's right, you may be in possession,
Yes.
but the person who has executed it, after taking money, you will give back to him, no?
That document was returned by me.
How?
And because I had paid the money.
No, merely because a person paid the money, the Bukut Banga
No, it shows that my position, it shows my position.
You cannot show your possession.
Yeah, that shows my position as because if suppose somebody disputed a mortgage and not a possession is with me, then had they produced the mortgage deed itself, then it would have been said that there is something else. This is also one of
It
the.
is not your case. Your case is that mortgagee handed over the document to you.
Yes.
It is not a case that mortgagee handed over the document to the mortgager and the mortgager handed it over. That is not your case.
My case.
If somebody else gives the mortgage money, the property will go to that person.
The relevant point for consideration would be that if suppose the original document is being produced, then the presumption goes that the person.
No, presumption. You see, you don't get title by it.
But I was in possession. That is
Maybe you
that
might
is-
be in
that is-
possession,
that
you do
is-
not know
that
if you
is-
are in possession or not in possession.
Thereafter, the further case will that Sheikh Shedi, Bibi Gafina and Bibi Jaitu wanted to dispose this property. So, they preferred a suit that is 125 of 1960 in the court of SDO, Goda, for declaration of title and for recovery of possession. This suit, you will see, was transferred to the file of MB Hassan, DT collector, Goda.
This suit was filed by whom?
This suit was filed by Sheikh Shedi, Bibi Gafina and Bibi Jaitu, who had granted Kurfana.
Kurfanama. Sheikh
Sheikh Shedi,
Shedi,
Bibi Gafina
Gafina
and Bibi Jaitu.
and
Bibi Jaitu,
Jaitu seeking recovery of possession.
seeking declaration of title and recovery of possession. That suit, you will see, was dismissed. And Exhibit 7 has been brought on record by us. My Lord will find from that particular judgment that I was in possession and I was in possession for more than the statute. That is the reason the court said, recovery of possession cannot be granted.
You were in possession since when?
I was in possession prior to 1940. That what is the document?
Prior to 1948 means 2000 years also. I just want to know what is your case. Since when were you in possession? You are claiming adverse possession.
My Lord, the moment the Kurfanama was disputed.
That is in 1948.
1948.
Okay.
And a specific date you will see is 15/5/1948.
So you were in possession according to
I am in
15/5/1948.
possession since then. And it has come-
15/5/1948.
And it has come in that document also. There is an admission on their part.
That document we really cannot see much about it.
Exhibit 7, my Lord, we kindly see. We kindly see Exhibit 7. That is the point which is to be
So you were in possession from 15/4/1948.
since the Kurfana.
Since Kurfanama, that is 15/4/1948.
15/5/1948.
15/5/1948, just less than a year from coming into force of the SPT Act.
Yes, but in that particular document, it is written. I will be permitted to read it without the application. मन के से खेती से सांजो मुतफा वो मस्मात गफना जो से कंट्रोल होकर से सांजो वो बिनी जरूर जो से कम्युनिटी साकिना भाट कमिटिया नाना महागामा सब डिवीजन बोर्ड जिला कार्यालय संथाल पर वाले वो बाकी मौजा घाट कमिटिया नाना महागामा के इसके सर्वे में शेख सांगोर से अब्दुल से बयाज से कमरुद्दीन और से कालू वगैरह के नाम से पहचान दर्ज हम लोग लेखाधिकारीगण ऊपर के दर्शाए गए जमा
सर आपका सब्सटेंशियल क्वेश्चन ऑफ लॉ इस तरह से नहीं बना हुआ है।
हम इसको पढ़ रहे हैं
पढ़ रहे हैं ठीक
इसलिए
है, लेकिन सब्सटेंशियल क्वेश्चन ऑफ लॉ इस तरह से नहीं बना
आप कितने साथ साथ
नहीं कितने आपका क्या प्लेन आप प्लेन से दिखाइए क्या आपने प्लेन से आप दिखाइए व्हेन विल यू पुट इन पोजीशन यू हैव टू गिव अ स्पेसिफिक डेट as per the plane show me which paragraph is your date of possession.
I'm sorry.
What is the date of possession given
Yes,
in your
ये राशि में काली सी पास
and put the possession that is 15/4/1948 that is your specific case in para 7.
Yes.
So why do we need to read that? It is your specific case.
Not was asking that since one, but in the paragraph in the exhibit 2 it is itself written prior to 12 years. That's what is written.
Prior to 12 years in
Prior to
exhibit.
that coming into force from the act.
No, but that is not your case.
My case was achieved.
Your case is that you were put in possession on 15/5/1948.
Yes, see, that
So you cannot refer to a document which says that you were prior to 1949, 12 years prior to.
Exhibit 2 is the
No,
document
you
admitted.
see, you cannot have a case which is beyond your pleadings.
Yes, I agree.
Then
My
That is not your case.
Urfanama was disputed on 15th of May 1940.
that's right.
But in the document itself it is written.
Mr. Sharma, please appreciate you cannot make out a case which is totally contrary to your pleadings.
No, I agree to that.
Whatever might be written in that Kurfanama,
Yeah.
we don't bother about it.
But
You never made out a case.
what-
Rather, you will see you have not even made out a case of adverse possession.
No, I have specifically said.
So your at best your adverse possession is from your possession is on 15/5/1948.
Yes, I will read those documents. My lord will
Not those documents. You have to show it from the plaint because
I'm
foundation pleadings has to be there in the plaint.
I am showing it from the plaint itself. Kindly see parasite.
Yes, you read parasite.
But give the lands to Kulfa to plaintiff and they executed a Kulfanama in favor of plaintiff and put the plaintiff in possession of this.
Yes.
So far as the land ownership is concerned, immediately after execution of Kulfanama, as per the plaintiff, that is 15/5/1948, this plaintiff came into possession. There will not be para 8 your lordship we have specifically stated that since after Kulfanama was disputed, plaintiff has been coming in actual cultivating possession of the soil openly and adversely on the expiry of the statutory period.
When did the statutory period expire?
The statutory period is 12 years.
When did it expire as per your calculation?
1948, 12 years, 48, 58, 60. And the plaintiff
15/5/1960.
plaintiff acquired valid legal right, indivisible right, indivisible right to the title in the suit land. And the plaintiff has been paying 3.75 Urfa rent to Sheikh Shedi and others, and he is getting rent receipt in respect thereof. Bibi Gafina executed a Bhagat Banda on 9th of April 1962 in favor of Ram Leena Bhagat in respect of plot number 153, 146, 157. But as the plaintiff was coming in possession of plot number 153, 167, refused to allow Ram Leena Bhagat to get possession, who decided to take back the money from the place and to return the document to him. Plaintiff said paid the amount and got the document back. They got the deed after endorsement. That Sheikh Shady, Jafina and Bibi Jaitun wanted to resume suit land by disposing the plaintiff. But the plaintiff has perfected a title in the suit. He refused to give up possession. Whereupon they filed title suit 125 of 68 in the court of SDO Vada for declaration of title and recovery of possession. This suit was transferred.
This was filed against whom?
It was filed against me, Dariel.
So it is same parties.
Same. Both, all the three persons filed against us. It was transferred to the file of Sri M. Hassan, Deputy Collector Boda for disposal. Both the parties adduced evidence in the suit, and the suit was dismissed by the court of its judgment dated 4/11/1968, and it was held that the plaintiff had required valid title, legal right, tenancy right by adverse possession against the said decree no applicable. That the defendant's second party, who is full brother of the plaintiff, out of malice and guilt.
Just a moment. This particular document, the suit, which is the subject matter of consideration in the second appeal, place that.
Yes.
And it attained finality.
Yes, and because no appeal was filed.
What are those miscellaneous appeals? Second,
Yes.
8 and all.
I'm coming to that. The second party, second defendant, second party, who is my full brother, he instituted eviction proceeding under section 20 and 42 of the Santhal Paragana Supplementary Provision Act 1949. That was dismissed. Again, that the appeal was allowed. And again, that the revision was also dismissed. So, that is the proceeding under section 20 and 49. And in those proceedings, my lord, we find that
Your brother is not a party to the suit.
he is the party, and he has filed a written statement supporting me here.
No, not here. In that suit of 125.
No, he was not.
He was not a party.
He was not.
Which is that exhibit 7.
Exhibit 7.
You read.
I'm reading.
This adverse possession was declared.
Yes.
And then this, nobody filed any appeal against this.
Yes.
Then,
Well, in those proceedings, eviction proceedings, which I was just referring to, which was filed by one of my full. But in those proceedings, the revenue courts, your lordship, said that it is a sort of a policy talk. And my lord, that what is the stand of the my lord, independent third party.
Did your brother had any right to the property in his capacity? Who filed the revenue after this revenue suit? Firstly, your brother was not a party to this revenue suit.
Yes.
Correct?
Yes.
He was not party. Now he initiated another proceeding. Where is
Just-
that? Where is
just-
that exhibit?
It was out of malice and guilt that what
No,
we have
whatever
did.
be it, but Sheikh Jar Ali was the petitioner,
Yes, that who was the plaintiff.
who was a defendant in the suit.
That here it is different.
No, Jar Ali was a defendant in that title suit number 125 of
Yes,
1968.
and here
And
it
he
is.
became the applicant in subsequent proceedings before the Revenue Authority.
No.
Yes, it is there. You just see Exhibit 8.
Exhibit 8.
Zar Ali is the petitioner.
In the eviction matter.
Exhibit 8.
Yes, I'm confused. Exhibit 8, Your Lordship, the appeal was preferred, thereafter the revision was also. In the appeal, the order of the SDO was set aside. Initially, the SDO refused to exercise the eviction.
If those orders were passed, you refer to the order.
Yes,
You just tell us after Exhibit 7,
yes,
which exhibit should I look at?
yes. First, Your Lordship, may kindly see. RER case number 26 of 1968-69.
26. That is exhibit number?
It is the exhibit number. It is exhibit number 6.
This is after this suit. Yes, exhibit 6 is after this suit. No. You see, 1968 was suit which was filed earlier. 1968 suit was decided on 4/11/1968. Right?
Yes.
Just a moment. Title suit number 125 of 1968. Madam, please take down. Yes. Title suit number 125 of 1968 was filed by Sheikh Khedi, Bibi Gafina, Bibi Jetun against Jar Ali, and adverse possession of the plaintiffs in the suit was declared by the court, by the Deputy Collector Godda in the suit by judgment dated 4/11/1968.
Their title suit was dismissed. Their claim for title was dismissed, and because I was found in the
Okay, the suit was dismissed by observing that Jar Ali had perfected his title by way of adverse possession. Okay. Then this RER case number 26 of 1968-69.
it was filed by Tasneem, Sheikh Tasneem.
Okay. RER case number 26 of 1968-69 was filed by Sheikh Tali of village Kamaria against Sheikh Khedi, Bibi Gafina and Bibi Jatu.
Yes. And this was dismissed.
Under section 20 of the SPT Regulation Act, and this petition was dismissed by order dated 22/5/1970.
Against which an appeal was preferred.
Against this order, an appeal was preferred. इसमें लिखिएगा ब्रैकेट में एग्जिबिट 6, पहले वाले में एग्जिबिट 7. अपील was preferred. The appellate court's judgment is in exhibit. Exhibit 8. Exhibit 8 is not appellate court's judgment. This is SP Revision Miscellaneous 10 of 1971-72. This is not appellate court's judgment. The appeal against the state judgment was numbered as Revenue Miscellaneous Appeal number 172 of 1970-71, which was filed by Sheikh Talib Ali against Sheikh Jar Ali and Sheikh Shedi Mausamat Bibi Kafina and Bibi Jaitun, which was decided by judgment dated 30/4/1971. And the appeal was allowed.
Yes.
By observing that and consequently Sheikh Jar Ali was directed to be evicted from the plots mentioned in Kurfanama dated 15/5/1948, and plots were directed to be restored back to the respondent second party, namely Sheikh Chedi, Masamat Bibi and Bibi Jatun.
Against this,
And the land would become available for settlement with local deserving rayats. The findings of the appellate court is in paragraph 6, 5 and 6, which is quoted by that. Yes. Against this claim.
against which the revision was preferred.
Against this order dated 30/4/1971, passed in revision miscellaneous appeal number 172 of 1971 within bracket annexation 9, a revision was preferred, which was numbered as SP revision miscellaneous number 10 of 1971-72 and was decided by the order dated 20/5/1975. The petitioner in the revision petition was Sheikh Jar Ali. Jar Ali क्यों revision इसके against में फाइल की?
The appeal allowed. Order of eviction was passed.
अच्छा, he was evicted. Okay. What happened in this?
Yeah, dismiss of it.
This appeal was dismissed.
This revision was dismissed.
Sorry, this revision was dismissed.
Appeal was allowed, revision dismissed.
Okay.
The original proceeding
And the
dismissed.
yes.
Appeal allowed,
allowed revision dismissal. Fair enough. Now, in the title suit now,
Well,
who is the applicant? Who is the plaintiff?
Jar Ali.
Jar Ali is the plaintiff in the present case.
उसमें वही कॉज ऑफ एक्शन था जो उसको हटाने वाला जो चक्कर था उसके चलते उसको पहले प्रेयर में लेके आए थे
ठीक है.
बाद में डिक्लेरेशन ऑफ टाइटल में किया
That was a proceeding under section 20 of the.
20 of the Supplementary Provision Act.
That's right.
Listen. But the
So initially you had challenged this order also, but that challenge was not ultimately
eviction.
No, you challenged this order also, the order of the revision in the suit.
The revision order is passed by the appellate authority.
The suit. Okay, madam. In the present case, Jar Ali is the plaintiff, and initially when the suit was filed, the order of eviction passed by Additional Deputy Commissioner in Revision Miscellaneous Appeal number 171 of 1970-71 dated 30/4/1971 and the order dated 20/5/1975 passed by the Commissioner Bhagalpur in SP Revision Miscellaneous case number 10 of 1972 was challenged, but by virtue of amendment, the challenge to these orders was deleted and the suit was confined to declaration of title and confirmation of possession.
The main, not both the courts, particularly the trial court. Trial court had said, relying on the judgment of the appellate court and the criminal court in those proceedings, that this is the policy law. Actually, the Jar Ali.
Trial court means trial court in the present case.
Yes.
Where is that finding?
Yes. That is the reason why the matter has been admitted.
That original suit was a collusive document.
Yes.
Because that was the finding in the section 20 proceeding.
Yes. So how can it be binding on that? That's what I was saying.
No, you see, section 20 orders are subject to their own remedies under the SPT Act. Is the order passed under section 20 can be set aside directly or indirectly in a suit?
That's why that has been deleted. I am asked to declare my title.
Yes.
The Lordship may candidate. It can be, it is a separate forum. It is a separate forum. And whether if suppose the revision has been
If
dismissed.
there is an order of eviction passed by a competent authority under section 20 of the SPT Act,
Well,
and that order has attained finality,
well,
because ultimately that was never challenged, and in the suit also that the prayer was deleted. Then under such circumstances, what is the consequence? Then a parallel order of declaration of your title and confirmation of your possession.
So far as your Lordship, there is a difference. That what I was saying. But in those proceedings, order of eviction has been passed.
That's right.
And till date we are in possession. That has not
In
been
those
issued.
proceedings, the order of eviction has been passed by recording a finding that it is collusive.
The finding has been recorded.
Yes.
The basis of my claim, that is the basis of my claim, Kulfanama and not those Google Banda or and
No, the finding is that the
Suit
entitled
was-
suit was collusive. That is the finding.
Meaning thereby, what it does mean that there was a collusion between me, the Jar, and the persons who executed Kulfanama.
No,
That is
the
the-
collusion is with regard to the title suit, because in the title suit adverse possession was declared,
Title suit, your
which was contrary to the law.
The title suit was fought between the Gafina and others who executed Kulfanama in favor of my favor.
Yes.
And if suppose that was a possessive suit, then my lord,
You were also a party in the title suit.
I was the main party. My brother was
Yes.
not party.
Maybe.
My mother, he is
Brother means who? What is the name of your brother?
Sadiq.
Okay. He was not party in
He
that.
was not party in that.
Okay.
And now, my lord, the revenue court has said, no, this document is for receipt. How it can be?
You see, but that order by which the revenue court
And-
has said
and-
that
and-
it is
and-
collusive
and it is the
is
same-
not under challenge.
No, that is the main document which requires for account.
Which is not under challenge. You have deleted the relief in connection with that.
That has not been.
Yes, that has been deleted.
No, so far as the exhibit 7, Your Worship. Exhibit 7 pertains to declaration
Your-
of their declaration of title.
Exhibit 7 is not deleted. The point is that by virtue of subsequent orders passed under section 20, the exhibit 7 was found to be held to be collusive.
That is the reason for the title suit. How those courts can not comment upon a.
But why did you delete your relief? Why did you delete your relief? You should have retained it because you were challenging that this finding of the court under section 20 of the authorities under section 20 was not correct.
Perhaps,
But you have deleted that
perhaps
relief.
as such, it could not be directly challenged. That is the reason why it must have been deleted. Because in CNT also, there is a bar. 258 is bar. You cannot challenge
Directly or indirectly.
Directly or indirectly. But one declaration of title, one as per the full bench judgment, Paritos Maithi's judgment, my lord, I have cited, you also be aware. One in that judgment declaration of title is always maintained. More or less the provisions in the Chota Nagpur Tenancy Act and those are to some extent are parametric.
Where is that judgment of Paritos?
Paritos Maithi's judgment.
तो फिर आपका तो ट्रम्प कार्ड वही है, और वही नहीं लेके आए हैं।
But it is reported in 1987.
इससे हम लोग तो मेमोरी से नहीं चलता ना।
1987.
बताइए पारितोष मैत्री का जज।
Paritos, 1987. It is a BA there, 1987.
The learned counsel has relied upon the judgment passed by the full bench of Patna. In the case of Paritosh Mehti, though passed in the context of Chotanagpur Tenancy Act, but submits that the same principle would apply in the present case also. There cannot be any bar seeking declaration of title, even if the revenue authority have passed order under section 20 of the Santhal Pargana Tenancy Act directing for eviction of the plaintiff of the present case. That's all. और क्या है भैया? He submits that under such circumstances, the judgment passed in title suit declaring the adverse possession of Jar Ali, who is the plaintiff in the present case and defendant in the same case, has become final, and therefore the exhibit 7 has not been properly considered by the court. The exhibit 7, if taken into consideration, there can be no dispute with regard to title of the plaintiff and
Position acquired by title acquired by
title acquired by adverse possession, and it is the specific case of the plaintiff that they are in possession of the property. That's all.
in this is the only.
आपको
Now
क्या
let me
लगता
show.
है? अब क्या बचा है?
जजमेंट दिखाते हैं।
हाँ?
इसमें जजमेंट से दिखा देते हैं। ये कम से कम अपीलेट ऑर्डर तो हम लोग एकदम जाने लगे।
अब सुन लिए ना आपका।
इसका जाने लायक है, इसको इसमें कम से कम एग्जिबिट 7 तो प्रॉपर कंसीडरेशन
तो प्रॉपर कंसिडरेशन नहीं हुआ तभी ना सब्सटेंशियल क्वेश्चन ऑफ लॉ
और
बना।
ये भी नहीं देखा जाए, इसको देखा जाए।
ये देखिए जरा पेज नंबर 20 ऑफ द ट्रायल कोर्ट जजमेंट।
Well, two zero.
Having given the aforesaid background, the learned counsel for the appellant has submitted that the trial court recorded that the judgment passed in title suit number 125 of 1968, within bracket exhibit 7, was challenged before the deputy commissioner, within bracket additional deputy commissioner bracket close, in revision miscellaneous appeal number 172 of 1970-71, wherein it was recorded that the judgment in title suit number 125 of 1968 was collusive.
No, no, subject to
The
correction.
learned counsel has submitted that the judgment passed in title suit number 125 of 1968 was never challenged, rather the proceeding was initiated in under section 20 of the Santhal Pargana Supplementary Provisions Act, and therefore the learned trial court has committed error of record in recording such a claim. और बताइए।
Then my lord, मैं kindly see the other activity. But up to para 7, but case of the parties etc. has been discussed.
That's
And some documents also, Panama etc. And the arguments of the both the councils. Then my lord, may kindly see the para 8.
yes.
After having considered the lower court record, this my lord,
Yes.
evidence documentary this court gave sincere thought to the argument advanced thereupon democracy issue for determination would be that appellant plaintiff would have any cause of action, he would entitled to get relief explained pertaining to the suit and disclosed in the claim. From the careful appreciation of rival claims advanced by the party plaintiff and contestant remains that is on exhibit to Kurfana. The genuineness of the same has been asserted by the therefore, said Kurfanama, which is on record in the Hindi translation of the also been supplied by the appellant which pertains to property. The Babandi number 20. It has been mentioned that the Jar Ali was close relative who helped them in the tight days of origins of the aforesaid land was said to have been given by Kurfa. The date of his question mentioned is 15/5/1940, a little prior to commencement of this meeting in the year 1940. Para 8 of the plaint contains a pleading regarding the aforementioned Kurfanama, upon the basis of which the Kurfa position has been made. So the submission of the learned counsel for contesting the respondent contrary to rule is not correct. The perusal of review judgment shows that the learned court, while deciding issue 2, that was relating to acquisition of title on basis of position by the title by the plaintiff and the finding to this effect that the witness has not been able to describe the title of the disputed property nor the Kurfa was written before him. Similarly, the next witness has also now been able to bring exact and they believe these two witnesses. As such, rightly discarded the testimony. By discussing the last witness, the disputed Kurfa, which has been said to have been written in court by one Bhuvneshwar, but he did not remember when the names of the victims. As such, his testimony pertaining to his question of Kurfa has rightly been accepted. Has not been accepted. There is a detailed discussion pertaining to this Kurfa by the court below. As such, submissions advanced by the court below is not correct, that the same was not taken into the judicial consideration. The court has elaborately discussed the oral evidence as well as the documentary. It is submitted that the plaintiff opponent has been lost earlier proceeding right from the due of information. In this reference, the relief sought for by the plaintiff by deleting the principal relief which was pertaining to this earlier judgment. An order passed by the revenue authority, the claim of plaintiff does not sustain. For the preliminary relief has been left, for the result there is a finding recorded by the revenue authority against this. The amendment relief could not have been granted. At it would be defeating circumstances converting the earlier judgment, circumventing the earlier judgment and order passed by the amendment in the authority. Once the ability has come into 1949, plaintiff has failed to prove his continuous condition of the property. For this finding, the court has given ample consideration to say Bajuddin PW1 in cross-examination stated contradictory himself, saying Kufa was not written before him. This testimony reverted back and saying the same was written before. PW2 procedurally is not definite whether it was written in 1948 and 1953. Witness Natul Mehta and PW4 Sultan have not supported it. Their testimony has been valid, not found by the learned court.
Just a moment. The learned counsel for the applicant has submitted that the first appellate
No
court has
consideration of-
recorded the finding in paragraph 8 of the impugned judgment, but there is no consideration of Exhibit 7 at all. The court has gone into the legality and validity of Kurfanama and was of the view that the trial court has rightly disbelieved the Kurfanama. Right? Rightly disbelieved the Kurfanama. This is the consideration of the learned first appellate.
No consideration with respect to exhibits.
Right. The learned counsel submits that if Exhibit 7 was considered, then under such circumstances, there was no occasion to disbelieve Exhibit 7 inasmuch as there was no scope to disbelieve the Kurfanama inasmuch as the Kurfanama was duly accepted as valid by the court, by the revenue authority in title suit number 125 of 1968, Wide Exhibit 7, which further became the basis of declaring adverse possession of the present right. That's all. ये भौरेलाल जैन and this देव नारायण सिंह, ये दोनों जजमेंट्स का रेफरेंस इसमें आया है. ये किस पॉइंट पे था भूल गए. दो जजमेंट्स का मैडम नोट करेंगे. यस मैडम, टू जजमेंट्स, ठीक है. AIR 1985 पटना 196 full bench, Dev Narayan Singh and others versus Commissioner Bhagalpur Division and others. And number 2, AIR 1973 Patna, full bench, Bhaurelal Jain and another versus Sub-Divisional Officer of Jamtara and others. ये दोनों क्या judgments थे? I have just forgotten the issue.
इसमें हम लोग कहना चाहते हैं ये मेन जो पॉइंट है जो ट्रांजेक्शन एग्जिबिट्स ट्रायल कोर्ट ने तो
To what extent Exhibit 7 is binding?
एक तो सबसे पहले ये
Exhibit 7 का सूट किस प्रोविजन में डिसाइड होता है SCT एक्ट में? लाइक
हाल पर रखना
हाँ, सेक्शन. The learned counsel has submitted that the suit contained in Exhibit 7 is referable to suit filed under section 5 of Santhal Pargana
settlement regulation 1972
Settlement Regulation 1972.
1870
1872 बस रुक जाइए एक सेकंड Section 5 is the bar to jurisdiction. Under what provision has been
during the operation? Settlement operation.
सूट कहाँ फाइल होता है? सूट किस?
Bar of civil court during the settlement from the date under section 9 of the government declared by notification until the date on which such settlement is declared lies in the suits and lie in the court established under the law. Any land interest or the value of contract, any village hardship committed in such between dates, such and such, all suits of nature shall be filed before or transferred to the officer appointed by the state government under section 2 of the Santhal Pargana Act 1885 or section 10 of the
He has referred to section 5 of the Santhal Pargana Settlement Regulation 1872 and has submitted that there was a complete bar in filing any suit in civil court established under Bengal, Agra and Assam Civil Codes Act 1887.
It's a 5-2 level.
And the suits were required to be filed before the prescribed authority
Then you can
in terms of section 5 within bracket 2.
plus 2. वो जो सूट होता है उसका अपना वैल्यू क्योंकि वो सूट ही एक्चुअल में डिग्री ये होता है उसका वैल्यू और रेवेन्यू प्रोसीडिंग में ये सब रेवेन्यू प्रोसीडिंग्स है जो कि 20 का ये सब उसका ऑर्डर को अगर पॉलिसी का है तो उसका कोई आधार कोई तो नहीं है और इसका कोई कंसिडरेशन तो अपील कोर्ट ने किया ही अपील कोर्ट तो इस पर गए ही इसलिए इनका जो जजमेंट है वो अपील कोर्ट का इट इज फ्री टू बी सेड
That's all.
मतलब मैं थोड़ा सा consultation of this. क्योंकि अपील ट्रायल कोर्ट का एक जजमेंट में उन्होंने कहा है कि ये थोड़ा संदेह से भ्रष्ट है तो अपील कोर्ट को तो कम से कम इस चीज को तो देखना चाहिए था कि हाँ ये कोई ऐसा पॉलिसी है कि इस पर तो कुछ गए ही
The learned counsel for the appellant has also submitted that the consequence of Exhibit 7 having not been considered by the learned first appellate court, it is a fit case for remand. लेकिन बाकी तो सब चीज़ यहाँ पर है, रिमांड करके क्या करेंगे?
तो इस पर बदलाव कर दिया गया
हाँ तो rather it's a case which is fit to be allowed, as all the documents and materials are before this court. And second appeal, once second appeal is admitted, it is a continuation of the suit. यही बोलेंगे ना?
2009 से
75 का सूट को हमको रिमांड करने का कोई शौक नहीं करना।
और भी अगर आगे
सॉरी?
पोजीशन में आज भी
हाँ, वो तो हम लिखा देंगे।
माइलॉट का रिकॉर्ड
पोजीशन का फाइंडिंग दिया है।
पोजीशन में तो हमको मान ही नहीं रहे तो कह रहे हैं कि आपका गुफा का कोई वैल्यू नहीं है सब पॉलिसी
शुरू में हम लिखा नहीं रहे, अपने मेमोरी के लिए ही है, इसको हम कर देंगे। The learned counsel has also submitted that the appellant is in possession of the suit property. Yes.
कल्टीवेटिव पोजीशन में भी है और इनका घर
हाँ?
कल्टीवेटिव पोजीशन में भी लैंड है इनका घर भी बना
In cultivating possession of the property and is having a residential house over the property. Yes. Sorry? When this court called upon the learned counsel for the respondent for his argument, he prays for adjournment. कितना कॉस्ट लगा दें बताइए? आप ही से पूछ रहे हैं। Yes. इसमें एक चीज और लिखिएगा, सेक्शन 63 of संथाल परगना सप्लीमेंट्री प्रोविजंस एक्ट 1949.
वो वाला हम जजमेंट
यस बताइए कितना कॉस्ट? कल कर लीजिए, ठीक है, बिना कॉस्ट के कल ही हो सकता है. No advance notice taking adjournment was circulated on behalf of the respondents. However, by way of last indulgence, at the request of the respondents, the matter is adjourned tomorrow. And in absence of the बस लास्ट इंटेलिजेंस से नहीं आइएगा तो हम जजमेंट लिखा देंगे, ठीक है? अब क्या लिबर्टी? अब जो जजमेंट ये तीनों जजमेंट लेके आएगा, भौरेलाल जैन, पारितोष मैती एंड ये सिंह वाला, क्या नाम है उसका? भौरेलाल जैन, सॉरी इम्प्रूव जजमेंट में ही लिखा हुआ है तीनों जजमेंट. एक ये देवनारायण सिंह. अब दोबारा एडवर्स पोजीशन थोड़ी डिक्लेयर होगा, एक बार हो गया.
हमारा वही केसी एक बार डिक्लेयर हो गया, उसको भी कल रिसीव करें.
But the point is, if the suit is not barred, then everything is open. If the suit is otherwise not barred, why did you go for a declaration of title when it was already adverse possession आपका declare हो ही चुका था? You were in possession.
Threatening of eviction.
What threatening of eviction? Injunction फाइल करते हैं ना? Declaration of title किस लिए फाइल करते हैं? नहीं, आप बताइए, मतलब अपने ऊपर खुद ही कुल्हाड़ी मारने को तैयार हो गया. अपना ही टाइटल डिक्लेयर, जब ऑलरेडी यू आर इन पोजेशन बाय वर्च्यू ऑफ ए डिक्लेरेशन थ्रू एडवर्स पोजेशन, व्हाई डिड यू फाइल? हो गया, गलती हो गया, इसीलिए सेकंड अपील में झेल रहे आप.
डिलीट भी कर दिए राइटिंग के लिए, क्योंकि वो प्रेयर तो इसमें सुनते नहीं.
वो प्रेयर उसमें सुनते नहीं तो वो भी तो ऑर्डर फाइनल हो गया ना.
नहीं तो उसका अगर रिविजन हो सकता है.
The point is, you say that the suit was maintainable, right? When the suit for declaration of title was maintainable, then you cannot say that other aspects of the matter will not be taken into consideration. Everything is open there. You can't have it both ways, no? That my title has already been declared, I want another declaration of title. दोनों चीज कैसे चलेगा? You file a suit and you file a suit for seeking a declaration of title, and you say irrespective of any orders passed by the revenue authorities, this suit is maintained. Correct? Once the suit is maintainable, then everything is open.
There is at least not maybe suit was filed by the finance against me.
But adverse possession was declared in your favor.
And that suit was dismissed, and my position was acknowledged.
So, not acknowledged. Your adverse possession was declared.
Declared.
फिर दोबारा?
और जब इन्होंने eviction में चले गए और eviction में हमने जब डिस्पोजेस करने के लिए एकदम आमदा
कैसे?
सूट लेके आए, सूट में ये सब का ऑर्डर चैलेंज हुआ, बाद में उसको डिलीट किया, अपना डिक्लेरेशन ऑफ टाइटल जो कि एक्चुअल में मैटर नजर था वही फाइल.
चलिए देखते हैं. Yes, madam, your case. Madam, it was your first case. You ought to have been here. Sorry? No. It is part third matter. I told you tomorrow itself that it will be taken up as the first case. I don't know. I tell you something in the court and something is not mentioned in the list, and you will say it is not mentioned in the list.
Possible case item 2.
उसमें डाल दीजिए.
This one,
दूसरा एक केस में CAD है.
which was hard.
ये किसके पास था ये फाइल? I don't remember किसके पास है. चेक करिए. उनको हाथ में हैंडओवर करने दीजिए. Yes, madam.
Yes, ma'am. A short synopsis, the argument has been over. Only I want to conclude and point out some portion of the argument. In continuation of my speech, Alex sir has been mentioned in the exhibit and the page and paragraph 29 onward. And in continuation of my earlier yesterday's argument, I want to point out in paragraph 29, 23 of the 29, 30 and 31 of the court petition and that it will page, paragraph 29, page 27. Terms of the reference only for the page number 27, paragraph 29. It is stated that the NCW only different is 2 point something rupees, and we are entitled, our claim is that we are entitled in terms of the settlement. Paragraph 29, I am reading. It is stated that the NCW 5 is effective from 1791. The petitioner 91 to 36, 1996 for 5 years and minimum wages under clause 221 of rupees 82.27 per day, but the chart of the management exhibit M1 shows less than it and conversion rate is based on NCW 3 L4, which has been modified and revised with effect from 1991. We claim the benefit of the NCW 5. And NCW 5 is the base structure, and NCW 5 is came into force on 1/7/1991, and it was continued for 5 years, that is 36/1991. In pursuance of the base structure in the NCW came into force in NCW 5, we are entitled the pay scale which is mentioned in the entitled the rupees 82.27 per day, which is mentioned in the paragraph 29, and in the chart also that is correct.
Which chart?
The chart, my lord.
Which chart?
Yes, ma'am. The chart.
Page 71.
Yes, ma'am. Yes.
You come to page 71, serial number 1.
Yes, ma'am. Much of this. Page 71.
You are calculating it as 13 into
13
2.64.
13 years, my lord.
13 years is counted from when? What is the year?
From the date of appointment.
Which is, just tell me the period for serial number 1.
That is the period 13 years.
बताइए ना कौन सा साल से कौन सा साल में?
Date of appointment is 36 1963 in the column.
36
column
1963 to
63.
yes. This is not 13 years. You are counting from which date?
No, 63 to 93.
Yes,
Date of
63 to
placement of the-
93 is how many years? 30 years. From where do you get this 13
Now,
years?
my lord, they have given the chart. That is not referred by years.
No, you are relying upon this chart.
Yes,
Yes.
that is not
And it is not your case that you want it for 30 years.
No, 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 13.
13. So I want to know that you claim
Number of
2.64 for 13 years.
13 years.
It starts from which year?
Date of appointment से नहीं है तो बता रहे हैं. Date of placement of MC 2 होगा 93 because the chart has been prepared for 93 cell. 93 cell. Date of placement of the MS 2.
तो 93 से कैसे होगा? 93 से तो you have been placed.
You have been placed as a
1993 minus 13 years. At best. Correct?
But this chart is not disputed.
Madam, I have to understand the calculation.
Whether the calculation has been made by them. I have
They have also given another calculation. Come to page number 76. Come to page number 76.
76.
Yes. With respect to the first person. Sorry, 70. Yes, page number 76.
Yes,
Right? They have also calculated it for 13 years.
13 years.
Yes.
Therefore, that is
But the rate for part period is 0.70 and the rate for part period is 1.32. And you are calculating the en bloc period as 2.64. This is the only difference.
I may not be clear. The chart which has been mentioned in the page 71 has been prepared by them, not by us. Therefore, there is no dispute for that. 13
No.
years or whatever.
Then this page number 76 is also prepared by them only.
They have given
Page 76. 13 years. For 5 years it is 0.70 and for 8 years is 1.32. At the top you can see.
that is a fitment chart. That
Yes,
has
this
been given in
is
the
also
fitment-
fitment chart.
Yeah, fitment chart.
Yes.
NCW4. When can you see
Madam, I am
NCW4?
seeing that.
Yeah.
But, Madam, please appreciate. Right? Firstly, we are in weak jurisdiction against an award. Unless you are very, very clear and you are able to demonstrate something which is especially incorrect.
I am saying, I
I am just comparing two charts which you have placed on record. Correct? One is at page number 71, other is at page number 76. And the only difference is, which I could gather, is you have calculated 2.64 into 13, and in page number 76, that 13 years has been bifurcated into two parts. That is, under NCWA 3, it is 5 years, and NCWA 4, it is 8 years.
Page 76, kindly see.
You see at the top.
Yes, that is NCW 3 and 4.
Yes.
Am I correct?
Yes.
3 and 4 has been calculated. What are you calculated for the benefit of the NCW 5 with effect from 91? Because it has been implemented with effect from the 91, 1791, the chart which was produced yesterday by the concerned lawyer. Therefore, madam, NCW4 was up to 91, up to June 91, and 1791, the chart is that 1791, NCW has come. We are entitled the NCW1 with effect from the date it has been implemented.
Okay. So you were in service
Yeah.
during the period 1991 to 1993
No,
under NCWA 5. Under NCWA 5, when NCWA 5 came into force in the year 1991,
with
right?
effect from-
with effect from 1991.
Yes.
So you, from the NCWA 5, you can have the benefit at best from 1991.
Yes, I am
Right?
telling that.
Just a moment. And under NCWA 5, your this conversion was 2.64 under NCWA 5, but not under NCWA 3 and NCWA 4. Now you are claiming for the entire 13 years at 2.64. Explain. It is not your case.
Whether I am claiming, can you see the chart?
Yes, I am there with the chart.
Yeah.
It's open.
Yes. They have given that chart also.
How do you claim for 13 years at the rate of 2.64? 13 years लिख के आपका चार्ट में लिखा हुआ है which you are relying upon. Am I correct? This is the whole case. ये देखिए पेज नंबर 71 में 13 into 2.64 and पेज नंबर 76 is 5 into 0.70 and 8 into 1.32.
Marathi years has not been mentioned in the page 17.
It's mentioned.
It's your document.
You see,
No.
I will tell you from where this year is coming. This year कहाँ से आ रहा है बता रहे हैं. I'll give you the dates from where this period is
That's a
coming.
number of star. And that is not the number of star.
That's right.
Star.
Year wise, no, every year.
Yes, every year.
Yes.
That's why 13 years has been. When they have been converted as a star, they are entitled for the benefit of the star. That is according to the according to the settlement. That is page 56. Settlement is that when the time-rated workman has been converted to the piece-rated workman will be converted to the time-rated workman. They are entitled for the star. So when they have been converted, that star has been they are entitled for the star. So therefore, the years, that is 13 years, that is the calculation which has been given by them also, and they have relied upon that calculation, because on that calculation they have paid 89.6, paid 71. Though we claim 107.54. On which basis we have claimed, that is in the chart. Kindly see the pay revision, revised pay structure, which they have shown yesterday. That is the chart, my lord. Chart in that is mentioned in the chart, that is also annexed in our regional date 21/6/2018. Yes, that is which was produced by them. As per NCW 4, this is before your lordship, supplementary activity on behalf of the petitioner respondent. Yesterday, which has been given.
Yesterday that there is a written submission.
That is the supplementary evidence also been filed on behalf of the respondent.
You were referring to the NCW.
Yes, ma'am. And so
I
that
am saying that. I am relied
on
upon.
the extra book was it given?
Yes.
Extra book.
I am relied upon. Supplementary activity on behalf of the petitioner, wrongly respondent. Yes. Paragraph 4.
First you come to this, not the paragraph, you come to NCWA straight away. They are referring to NCWA, you come to NCWA. It is there in the NCWA.
The chart is NCW 4 and 5. I am relied upon the 5.
Yes.
5.
You see the NCWA 5, it is there annexed along with that affidavit.
Yes.
Page number 12 of the NCWA.
Page number 12 also, page 3 also, the chart has been given. Yes, page number 12.
Page number 12, daily rated worker at the top. Revised base structure with effect from 1/7/1991.
First of all, kindly see the 2.2. 2.2, page number 13.
Page number
13.
2.2. Page number 3 doesn't
Internal
have.
page 6.
internal page 6.
What's internal page?
Last bottom only.
2.2, yes.
2.2.0, minimum wages, and then 2.2.1. I am relying upon 2.2.1. The revised minimum wages for the lowest paid employee on surface of the coal mining industry covered by this agreement shall be 2,138.70 per month and rupees 80.27 per day. We are the minimum wage, lowest paid employee. Therefore, per month we are entitled for 82.27 per day at the all India average consumer price index number of the industrial worker with such and such at such and such. This amount includes the minimum guaranteed benefit rupees 235 per month and 9.4 per day inclusive of the interim period.
I don't know from where are you including this. That is not your case in your writ petition.
My lord, that is my case. I am entitled. I relied upon. I am claiming 80.27, 80 rupees 27 per day. That is my claim. That is my claim and the benefit of the settlement. Nothing more. Benefit of the settlement, benefit of the NCW 5, and benefit of the 2.2. That is my claim. Nothing more. And
Which paragraph of the writ petition refers to rupees 82.27?
Yes, paragraph 29. Much of this. Page 27. It is stated that page 27, paragraph 29. It is stated that NCW 5 is effective from 1/7/1991 to 30/6/1996. For 5 years and minimum wages under clause 2.2 is 82.27 per day, which is and by the chart mentioned by the management, that is exhibit M by 1, shows less than it and conversion rate is based in CW 3 and 4.
So that is why I want to know if the conversion rate you are claiming SPRA. Basically, SPRA is to be given to you.
SPRA and the benefit of the NCW.
SPRA plus 82.27.
82.27.
Right.
That is the NCW.
And the SPRA is for 13 years.
Yes.
So I want to know from where do you get, can this SPRA at the rate of 2.64
Yes.
be extended prior to 1991?
No.
So
Definitely
2.64 you multiply it by 13. 13 is the number of years.
Number.
How do you multiply that? How do you multiply that? You just have a look at this NCWA, correct?
Yes.
And you come to internal page 12, right?
Yes.
You will get from where 0.70 has been taken.
Kindly see.
Daily rated worker under NCWA. You were the daily rated worker when this NCWA came into force in the year 1991. In the year 1991, you were daily rated worker. Peace rated, right? You were peace rated worker.
Yes.
So you will be covered by daily rated worker.
Yes.
Right.
All that.
Okay. Now you see this internal page 12.
Yes.
The category of daily rated worker under NCWA 4.
Yes.
This is 0.07. 0.70.
No, that is category 5. The daily
Yes.
rated workers is also classified. That is for 5.
You were not at daily rated category 5.
Yes.
You were adjusted under daily rated under.
And initially he was category 1. After he was converted to peace rated,
He came to category 5.
He was basic.
So initially you were in category 1.
Maybe. But
No, let us see what was your status. You were in category 1 and this is 0.70.
I was not. My claim is not based on the basis of the daily rated at 0.7.
I want to know in which category of daily rated were you there prior to your conversion into.
Yes.
Yes. Under which category you were?
I was in category 5.
Initially also.
When I have been converted?
No, conversion is in 1993.
93, 93.
I want to know prior to 1993, you were under which category?
Achha, first they were in the category 4. Yes.
Category 4, I don't know from where do you get
There is
this.
no such.
There is no such pleading, there is no such foundation.
My
And that is not your case.
my case is that
ऐसे instruction लेके थोड़ी चलेगा.
that is not the case of the management also.
And
I was in
no,
category
I am
1.
talking about your case.
Minor
Because you
case.
have to demonstrate the perversity in the
Yes,
order.
my lord, I have given the perversity because I was in the category 5 when I have been converted.
Upon conversion, you came to category 5. Before conversion, you were in which category?
Before conversion also we were in the category 5 in the daily rated workers.
From where do you say this?
Yes, my lord. Then I have converted to the category 5 in the revised pay scale.
No,
of
that is not your
5.
case. No, that is not your
Where is
case.
the case there? Before that
You
I
have
was-
to plead your
My
case.
lord,
No?
before that
You had gone.
when they denied that, I
Even
was
an
reinstated.
just an example of one of the workmate.
Yes.
If you also know about it. Just to give an example,
Yes.
para 6 of my supplementary petition. His name is also appearing in the list. There is no dispute whether he is not involved.
ये supplementary affidavit इसमें आ गया था.
Then ये list इसमें भी है, not my add quoted in this case also.
हाँ, in the written submission.
Yes, I quoted.
Tell me, you have given an example.
Just an example now.
Yes.
Para 7.
Hmm.
The petitioner name is Jharkhand. The initial date of employment is 31/5/1991. He was placed in category group 1. In group 1. I mean, if it was. Next is date of appointment as a minor. 1991. Date of placement in multi-skill crew, that is time rated, you say. He was placed in 1995. Since 1991 to 1995, he has 3 years of SPRA. I have given 3 years of SPRA. And next category one.
At what rate?
Yes, next, just I'll give. Can you see the next line one? Since he had earned 3 years of SPRA, so as per the SPRA at page number 17 of the NCW, he is entitled for at the rupees 1.08. So I have multiplied 1.08 into 3. So I have given my subsequently he was entitled for placed in category 5.
Yes.
So can you see your lordship just pointed out category 5 at page number 13 or 12?
Yes.
Category 5. Revised pay scale it start from 73.22. So we have added 73.22 plus 3.34. So its amount its total is 76.46.
Yes.
Okay, ma'am? Your lordship. Then I have given a chart. Revised pay scale का कि 76 fitment committee में नहीं आ रहा है. So I have given a higher, that is 78.50. So he was placed in year 1995. So prior to 1995, I have given 3 years of SPR as per his entitlement, and after conversion, that is time rated, he was granted annual increment in terms of the time rated, and this was also acknowledged by the tribunal award model, and subsequently he was also promoted to category 6. This was also recorded in the award. After getting treatment in 5, he was subsequently promoted to category 6. What he is entitled for. So
Your contention is that they have been given the benefit as and when NCWA came into it.
If NCWA come in 1996, by that time he was already promoted in year 1993, 1994, 1995 in the time rated work method.
Yes, he was already promoted.
Yes, he was already, but monetary benefit was allowed to be given at 1991.
That's
So what we have given since 1991 to 1993-94, just give an example, 1995, he was working as peace rated. It was peace rated. In 1991 to 1995, he was working as peace rated. So we have given allowances as per the SPR.
SPI, that is the annual increment.
Yes, ma'am.
That is
As per the Act.
2.64.
Yes, as per the Act. And subsequently, after 1995, I have given the increment which their witness has also admitted in the deposition. Kindly see para 22, ma'am. Last line. The piece rated worker get SPRA once in a year, and whereas annual increment are given to time rated workmen once in a year. So it is her case, in their case, my lord, कि prior to 99 fitment, he was entitled for SPRA. After fitment, he was entitled for annual increment. So we are giving the annual increment, and this was duly recorded by the.
But I want to place paragraph 5 of the supplementary which he has been placed. Kindly see that. As mentioned, paragraph 5, page 4. That is their own calculation. I am telling that. As mentioned in the table mentioned herein above, the basic rates of employees under category 5. I was in category 5 in the 1991 also. That 73.22, 2.64 and 110.80. We are claiming that the annual increment will be as follows. The chart has been given, and in the chart, rate of basic as per revised pay scale. Revised pay scale, that the paragraph 4 it has been stated the revised pay scale, and that comes 110.80. Just before that case can be considered, the chart has been given as per NCW 5 with effect from 1/7/1991. Before conversion, the SPRA, I am not entitled for the SPRA. SPRA is entitled consequent upon the settlement, in which it has been stated that whenever they are converted to their speed, time rated to is rated to time rated, they are entitled for the benefit of us. And the calculation is correct at page, my lord, page.
In your entire records, which calculation is correct?
My entire record is correct.
According to you, which is the correct calculation?
Their calculation in paragraph 5 is correct.
No, not paragraph 5. I am talking about your records. You must have, you have filed your petition. Which chart, which particular calculation according to you is correct?
That is 71.
Page 71.
71. They have given me my lord 89.6. Can you see 71? They have given me 89.6. Though I am entitled for 107 of 4, and that is in accordance with the chart of paragraph.
So annual increment according to you is 2.64 for 13 years.
Yes.
Right? But you are not aware which 13 years you are calculating.
I am not clear. And then I cannot say what. And is from that chart, my lord, 2 persons has given that benefit. That is serial number 17 and 20. They have given that benefit. And that is.
They were already working as minor.
That is also annexed in.
And we have to
Annexed at
there is price alert. So that since one by wrong, one has getting the wrong salary.
One was wrong and one was already working as minor.
And
That's why it is not getting any income.
And
wrong benefit cannot be given.
And wrong benefit cannot be, it has not been corrected also, and more so 5.1.
My understanding of these means right.
Which 2 persons according to you have been given this benefit?
Yes, page 69, that is a document. That is Super Sir Ram Ramesh Yadav. That is serial number 20 in page 71. 5/1, page 69.
69.
Yes. Further,
Ram Naresh Yadav.
Yeah, Ram Naresh Yadav. See, further to a letter dated 8/1/1996, we have to inform that your basic rate has been corrected as follows. That is 89.6 in the chart that is mentioned in page 79, 89.6.
Page 7. You are referring to page 71. No, that is your document.
Yes, that is their document also.
No, whatever it is, but you are relying upon page 71, right?
Yes,
With Ram Naresh Yadav.
yes. he was given the manual serial number 90 and he was given 89.6. Last but one column. 89.6.
It's 89.6.
And in Annex 551, page 69, it has been corrected. Your basic rate has been corrected as follows. That is in
Page
case
70.
yes,
Ram Naresh Yadav.
yes. That is rupees 89.6 in the first column as on 1/10/1994, date of conversion.
And rate given by management is 83.78.
Yes, he has given rupees 101 of 20.
So therefore, you say that 89.6 was given, but as given by the management, it is 83.73. 78.
No, 89.
As per page 70.
No, 70, second column.
No.
Yes, 89.6. After
89.6, there is another column also. At the
Initial-
top, rate given by the management.
Yes, 83 of 70.
83.7.
And initial rate of treatment as MSQ is 89.6.
Madam, you said that this person was given the benefit by the management,
Yes.
right?
Yes.
But this chart is showing that initial rate of fitment is 89.06 as per your calculation, but what was given by the management was 83.78.
In the correction slip, correction that is 5 by
Madam,
1.
we are looking at the chart only.
Well, kindly consider the chart. I said it has been mentioned in one place. It has been mentioned 89.6 that the initial rate on treatment as MSQ. I am correct to say that is 89.6.
So this chart is also not correct, because this chart is mentioning that he was given 83.78. There is a mismatch between the two at least.
My lord, this is match, my lord, the 1/10/1994. 1/10/1994 is mentioned against his name also. Kindly
Yes,
see.
yes, 1/10/1994.
The 1/10/1994, that
Four.
is 6.6 into 2, 64, 15.84.
Yes.
Then 73.82. Then 89.6. And then 83 of 78.
0.78 given by the management. So
Given by
this
the-
person, Ram Naresh Yadav, is also in the list of the workmen.
Yes.
If he has already got it, then why should he be there in the list of
It
the
has been
workmen?
given after, thereafter.
No.
98.
Reference कब का? What is the date of reference? It's 2001. According to you, he was already given. Then why is he one of the aggrieved workmen? He should not be there.
When the dispute was raised, हो सकता है इसको नहीं मिला है.
नहीं ये तो
Reference पहले kindly consider reference का पहले तो वो stage होता है, then reference will come.
that's
In
right.
the reference, that first will be at dispute may be raised before the assistant labor commissioner. That may be much before the date of reference.
But as per this chart also, what the management had given is 83 and not 89. As per this chart.
Yes, my lord. But 89.
So this person was also not given the benefit as per this chart, because you are heavily, you can't selectively rely upon a document. This document you are relying upon, and it is a document of the management. It says that this person was given 83.78 by the management and not 89.06.
Then this document is wrong.
Maybe wrong. We do
That
not know
is-
what ultimately
that is the
happened.
official document. They have not disputed
So-
that fact.
I do not know. We are not going to resolve all this here.
Jurisdiction in the case of
That is why in
the
lead jurisdiction we really cannot resolve
yes,
it.
madam. In the deciding the case of which fact has been brought and on record, and if there is any, my submission is that we are entitled on the basis of the settlement.
There is,
They are
I
not
think,
given
one
that-
person who was given. It seems that are not proper except one workman, Ram Naresh Yadav. Right?
Now the question is whether I am entitled for the benefit of the staff as I claim in pursuance of the settlement, which is annexed Ratna 5A, page 56. And whether the executive instruction as mentioned in the award can supersede the settlement. That is the purely
You see, there is no dispute that this settlement is binding. It is only the dispute is with calculation, not on the principles.
Not calculation. They have not given the benefit of the NCW 5 day fixation and on the on and from the day conversion the benefit was struck. Then I am and they are what they have said in the award. Can you see the last line? Whether that is according to the law or not, or whether it is not in accordance with law, rather contrary to the established law and ordinance. Can you see the last line after 89? That is page 89. After perusal of the consideration of the material, including aforesaid indisposable tax of the case record, I find that the pre-stated minor worker in the dispute management get only their group wages based on their workload beyond which the group.
This settlement was followed by NCWA.
Yes.
This is settlement of the year
Settlement of the year
1991, and NCWA has been made effective from 1991. Right?
Settlement is something that is under section 18(3) of the industrial.
30th June 1991. The settlement,
It's also of 1990.
but prior to that,
Like 5 months back, 4 months back.
4 months prior to that. And according to you, in terms of the settlement, only NCWA all these permissions were made? No.
No, we are not.
They were supposed to give this benefit through the NCWA.
Yes. So after coming to
My case is that I am entitled for the benefit
yes,
of the
and
NCW.
we are
as
also saying that
also-
he is entitled. All workmen are entitled for the NCW 5, which come in year 1996, but with effect to 1991.
Yes.
Our case is also they are entitled to.
And they are also entitled as per the settlement.
The only differences is with respect to calculation. We are saying since in year 1991 you are working as a piece-rated worker, so you are only entitled for SPR. Since you are converted in piece-rated or piece-rated to time-rated year 1994-1995, so in between 1991 and 1995 you are only entitled for SPRA, not entitled for annual increment.
That's
Only you are entitled for annual increment only after conversion in
2.64 is
Yes,
the
ma'am.
annual increment
That
and
is-
not SPRA.
No, ma'am. And he is getting SPR annual increment 2.64 after 1995.
1995, but they are claiming it prior to that. For 13 years, they are claiming 2.6.
Yes, sir, that is the calculation error.
That is the
Yes,
calculation
this is
error.
our calculation. And this was also recorded in the what we go promote below category 6.
This is subsidy.
The
That's
management had placed them in category 5 at the time of conversion. At the time
You
of-
see-
later they promoted.
You just have a look at this paragraph where they have given a calculation. Page number 26.
26.
Para number 26. They are calculating SPRA for 13 years.
26.
They are calculating SPRA for 13 years and taking 2.64, which is the annual increment amount, and calculating is at SPRA.
That is, can you see now NCW 5? 2.6 or 2 is well applicable. It is only applicable for time-rated worker. And admitted case of this there is they are converted into time-rated in year 1993, 1994, 1995.
That's right.
So and their deposition कि टाइम रेटेड वर्कर को एनुअल इंक्रीमेंट मिलता है और पीस रेटेड को एसपीआरए मिलता है देयर डिपोजिशन
That's okay. You want to say anything more, madam?
Yes, the paragraph 26 I want page 25. It is stated on implementation of NCW 5 related to the large rupees 89.6 per initial rate of treatment of category 5 of NCW A for MS2 will be 107.54 per day. Taking initial rate of category 5 as per NCW 5 will be 17.22 per day, which is added with increment earned by staff for rupees 34.32, 13 into 2.64, that is 34 to the 32.
Madam, from where do you pick up 2.64? 2.64 is where?
That is 2.64.
NCWA, show me 2.64.
Yes, 2.1.
2.64
Yes, yes. From the
is at internal page.
For already see page 17 SPRA का दिया हुआ है
Page number
internal last page 17 internal page
of this
yes sir. NCW
internal page 17, right?
Yes, sir.
Yes.
3.1.33 SPRA
Yes. SPRA rate is given here.
yes ma'am. So it was earlier NCW4 it was 0.070 and revised to 1.0
If SPRA is to be calculated at 2.67,
Yes.
is it mentioned in NCWA at internal page 17? Is this figure mentioned in page number 17?
Page number
17 of NCWA. 3.11.3.
2.64 तो है ही नहीं
2.6 को 2.2 का है
2.2 तो वो इंक्रीमेंट.
No, 2.2.1 revised minimum wages for the lowest paid employee on the surface of the
No, we are not on that. 2.67, from where do you pick up 2.67?
Yes, 17.
SPRA rate as 2.67, from where do you pick up? Page 17 does not have that figure. It is not there. It is not there. Your 2.67 or 2.64 is not there. I'll show you where is 2.67. 2.67 is in page number 12. 2.64. This is the increment.
annual increment वाला
Annual increment. This is not SPI.
Minimum wages has been mentioned in 2.2.1. 82.1.
No, 2.2.1 we have seen. I am just talking about the figure 2.64. From where do you
Yes,
get this
2.6.
figure? 2.64 is at internal page 12. In category 5, increment is mentioned as 2.64. This is not SPRA. This is annual increment. So you want to use this
Yes, my
as
lord, that is mentioned in page 16, right?
page
16.
no page called my page is 6 numbering
16.
your lordship page 12
Yes,
Internet
yes, and there.
That is running page 16.
Yes, it's
Yes, my
okay.
lord, that is
2.64 is the annual increment and not the rate of SPRA. SPRA is there in internal page 17, which is not there. 2.64 is not there.
It is increment.
This is increment, annual increment.
2.64.
Yes.
They benefit of-
This is not SPRA. SPRA is it in page number 17. Chali. Concluded?
No, I am giving to judgment on this. Yes.
Give me the judgment.
Yes. In the last portion of the award, 1.2
Yes.
So it is
Which judgment are you referring to?
yes.
Give me the list. You must have mentioned it in your written submission, right?
No, in the written submission in another place I am giving that.
I don't know, in other place.
That is 1200. Then award
Which judgment, madam? Give me the citation first with para number.
Then award the last question. Just a minute. Then award the last question I want to make. After that I page 89.
Yes, what do you want to show?
After quite contrary to yeah, that is in the third paragraph. Advocate for the union submitted that those workmen were permanently seated and aim loader of Jamadu related to management since their appointment date as per the list of the DISCO. The daily rated worker get annual increment according to employees' pay scale. Since piece rated worker have no fixed rate of pay, they got special piece rated allowance staff, but the minor note are having the other job, they had got engaged category rate of increment instead of SPA at per the settlement dated 7/2/1991. It is also argued that while converting the workman concern for piece rated months to time rated monthly skills view, the management paid them one SPA only instead of annual increment of category 5 rate of pay. Though the management has allowed one workman Ram Naresh Jadhav on the category 5 rate increment instead of SPA. Therefore, they claim the increment instead of SPA before conversion. Quite contrary to the suggestion, the management has contended that admittedly the workman initially appointed as a piece rated worker got their wages for their work done, so they are getting their SPA special by piece rated allowances which are an increment ever increasing annually, whereas the time rated workman shortly note and such got annual increment annually, and that the workman was converted into time rated worker with their wages protection of the Ram Naresh Jadhav. One of the workmen was wrongly allowed high rate of increment which was corrected as the basic rate but not of the annual increment as per management data dated 90. So the claim of the workman based on the aforesaid wrong case of Ram Naresh Jadhav for fixing the pay in time, job SPA and annual increment is incurred. After perusal of the consideration that is a finding including aforesaid indisputable facts of the case of record, I find that the piece-rated minor worker of the DISCO management got only their two wages based on their workload beyond which the wages were paid pro rata to them. 5 time-rated workers are given annual increment. Those workers already used to get SPA special allowances on their conversion into the minor time-rated workers category 5. They are given initial category 5 wages with their respective SPA earned by them and since their conversion 1993, 94, 95 as per circular dated. Can you consider as per circular dated 24, 1998, 16, 5, 16, 90 and 16, 6, 1995. 21, 11, 1995 XP respectively. Moreover, the authenticate copy of the two chart of the treatment committee as per management's both letter dated 21/7/99 related of those who were exhibited was this who was never a piece rated workman on implementation of the NCW 5. That given appeared to be consonant with the aforesaid circular. Therefore, which has been given, that has been findings is that is according to the circular. Circular as circular of the OP management. At this point, that is important. At this point, I am of the view that the LS wrong decision as per settlement. 12/5/2/1991, that is exhibit W1. That is the settlement on which claim of the union raised appears to be quite contrary. This whether that finance is purpose or not. When the settlement is there, they are bound to follow the settlement. That is a statutory force, and the executive instruction cannot supersede that. And so far the executive so far the data dated 24/11/1995. Page 81, can you see that? That is page 81, madam. Can you see 16/2/1995? The union has taken up the case for protection staff to the workmen who are transferred to page 81. That is 16/2/1995 in which the learning presiding officer relied and gave the judgment. The union has taken up the case of the protection of the staff to the worker who are transferred to time-rated category from peace-rated category. In the Indian management meeting held on 1/6/1995 at the level of the undersigned, after discussion, it was decided that if a peace-rated worker is placed in time-rated category even against advertisement, his PRA will be protected as has been earned in their as that increment. Therefore, I implement. Please note that the decision is effective from 1/6/1995. Therefore, the findings is based on the basis of the of this letter superseding the settlement which have a statutory force. And another letter is 26 April 1980. 80.
Which clause of the settlement
83.
entitle you are claiming SPRA or you are claiming annual increment or you are claiming both?
Anyone,
You are not claiming both. Certainly not.
we are claiming the benefit of the SPRA.
Okay. You are only concerned with SPRA.
SPRA as also the benefit of the NCW 5.
That's
NCW 5 category 5.
yes, we have answered.
And page 56 is the
Madam, order is reserved now.
Yes,
I heard you enough.
decision I will make.
Order reserved.
Therefore, my submission is that
I have heard you, madam. I am hearing you since yesterday. Whatever judgment you want to, on what point do you want to give the judgment?
more mark says that is 2007 volume 8 Supreme Court cases 541 that is so far the bindings of the settlement.
There is no doubt. Are you disputing that the settlement is binding? Settlement is binding.
Settlement.
There is no dispute on that, madam.
Therefore, on what basis the learned presiding officer has held that the perhaps it
We'll
is
see that.
Yes, madam. That is perverse filing. And that is the judgment. And another judgment is 2018 Supreme Court online, the entitlement of the benefit of the settlement.
Settlement is binding. You are entitled to settlement. The finding is that you have got as per the settlement, as I understand from the reading of the
My
award.
submission is that the findings
Last
of the land.
under 226 to 27.
With that you are giving the judgment. मैडम का भी जजमेंट ले लीजिए, नहीं तो उनको ग्रीवांस हो जाएगा, उनका जजमेंट नहीं है.
ना कुछ नहीं होगा, कुछ नहीं होगा, किसी से कुछ नहीं होता है.
Yes, item 3, the award has the order has come. क्या किया?
ये सब रिकॉर्ड करके
क्या किया? मतलब एडिशनल एविडेंस का?
वो तो हम लोग पूरा नहीं देख पाए हैं.
तो आप देखे नहीं ऑर्डर?
फर्स्ट हाफ में हम कोशिश किए.
मैडम का दोनों जजमेंट जो है ना उसी का निकाल. You have not seen that. You were, I think you told me that you are going there regularly, so you are not aware what happened.
I know what has happened.
You tell me what has happened.
The court has recorded all the evidences allowed and whatever has been marked, and then ultimately the court has given a finding.
What
That
finding?
finding portion I have not gone through because it was directly sent to
17.3.
that is the final. But it has, I have been told by the trial court that the advocate who was appearing that he has discussed it in detail.
Sorry?
4th April.
4th April.
It's in the second.
Wow. Well, ये order दिखाइएगा. Where is it? 4th April order.
It's kept here in the.
4th April of this court.
Here is fine. It is lying here.
Order दिखाइए क्या है? 17/3/26 का एक ऑर्डर दिख रहा है. उसके अलावा क्या ऑर्डर?
The one in the green with
वो 1/4 is one order.
the past order was 4/4 is the final.
वो 4/4 yes. 12 series has been accepted. And
one very important factor, that register 2 which they had produced here, they did not get it executed. So we
So
on
did
the
not
other
get-
hand, no, then we said, we asked the court to mark it, then at the back end, they agreed to get
The
it
trial
marked.
court has declined to mark our documents accepted as next. We filed petition to that record. The trial court
Ultimately,
said
it has been
that
marked.
since the
it has been exhibited, no, ultimately.
Yes.
our documents that we have pointed out to settle the issues that the matter was sent for, that those documents were not accepted. Only one document that
No, you see, the specific documents were indicated here only, which all are the additional documents.
to decide authenticity of the document of the AG, we filed the inquiry reports and all. That was not executed.
You see, there is no.
They have
There
filed
was a
another
specific
application.
order. You cannot add to it.
They're not adding. The order was also.
You want to challenge it?
Yes.
Tell me. If you want to challenge it, you tell
Yes,
us.
because we did not get the copy of the order. The file came here and therefore.
मेरे lifetime में decide हो जाएगा ये case? Are you sure? I have my doubts. हो गया कितना हो गया और कितना तो सब तो कर लिया, क्या बचा है? मतलब I have not gone through it.
I just went through the order. We were given 2 dates to.
Which document you wanted to be exhibited and was not taken on record?
We have-
Was it refused by an order?
Yes.
Which document was that? Was it a part of the records here? It was there in the additional evidence?
The IAs that we yes.
No.
No?
The IAs that we had filed for additional evidence, it was part of the.
No, you must have mentioned the list of documents. No, ऐसे इतना पोथा बना के फाइल करने से थोड़ी होता है. You must have, the list of documents must have been mentioned in your IA. Which is that document which was a part of your IA was not taken on record or not considered at all? Which document?
I do not have the entire details of the petition. Let me file an submission that.
My submission is very simple. The Lordship may take out whatever the reasoning the trial court has given. Now the evidences on the basis of additional evidence that has been recorded by the trial court, and my case
Oh,
may be
that
seen.
inquiry report have already been rejected by the court. So how could he take
And
it into
then they
consideration?
wanted to get it marked as
In
exhibit.
fact, you see, they say to begin with inquiry report number 188, dated 2/2/24, I find that the defendants tried to prove the same through evidence of DW4, Nimai Chandra Das, defendant number 6 himself, but this court refused to mark the same as exhibit in para 35 of his evidence, reason being that the High Court rejected the prayer of the defendants to produce the aforesaid inquiry report as additional evidence in IA number 3656 of 2025 in para 39 of order dated 28/11/25. That was already declined. How could he mark it? He couldn't have done it. No, I just read it because I think this is the only document which you are having, this inquiry report, which was not marked.
As per
That was already declined by the court. He couldn't have marked it.
let me file.
So how much time do you need now?
I do not have the copy of the.
So you take it out.
Yes,
When did it reach the court?
The matter was listed today. Solving.
That's right. You have not taken out the certified copy from the
No,
court.
we applied because the order was passed on 4th. The matter was sent on 6th to the Honorable High Court. Before that,
This is not an uploaded order. Do you want to say that the court is not uploading these orders? Is it not an uploaded order? Something very serious?
I suppose this is not.
Please check.
They have directly sent it to the
Without
court
uploading.
after recording. After recording whatever the direction was.
These orders
But
are to be
it is
uploaded.
but it is a part of the record now. They can take it out by way of
Now that the file has come here, should we take the certified copy of the
the scanned portions can be given to us. We can take it from the Honorable.
The learned counsel for the parties are present. The original order dated 4th of April 2026, as passed by the learned Civil Judge Senior Division, 1st Commercial Court, Dhanbad, has been placed on record. They pray for some time and submit that they would apply for certified copy of this order. By tomorrow you will apply?
And it may be supplied to us immediately.
The certified copy of this order be supplied to the learned counsel for the parties immediately upon filing of the act.
We have already filed.
You have filed, not filed. You apply it by tomorrow. You will get it by within a couple of days. आपका रिक्विजिट फाइल करने में देर मत करिए. आपको नोटिफाई किया?
हाँ, हम ऑलरेडी फाइल कर चुके हैं सर्टिफाइड कॉपी के लिए एप्लीकेशन.
When do I post it?
I'll only pray that next week if you are able.
When do you want?
If I find the requisites tomorrow.
When do you want the matter to be posted?
Next to next week. 1 week to 5 years.
Okay, whatever you have to file, you file. Next to next week आपको कुछ करने के लिए हम टाइम देंगे.
लेकिन
आपको जो करना है आप कर दीजिए.
he is a person, he is representing a person.
Whosoever, he is a party before this court.
Yes, but he has not filed appeal. The appellant is.
You see, I do not know. Whatever you have to say, whatever you have to do.
ठीक है. Therefore, I'm praying next week. But
अच्छा ठीक है, next week आप देखिए तो कुछ फाइल भी कर सकते हैं कि नहीं, कि फॉर्मेलिटी में फाइल करना. Right? I post it on next Thursday. अभी सर्टिफाइड कॉपी दे दीजिए. आप लोग इंस्ट्रक्शन ले लीजिए.
फाइल में हमने सारा भेजा था बंदा, तो वो फाइल में मेरे पास सारा.
कोई बात नहीं, अभी तक तो अभी सर्टिफाइड कॉपी तो मिल जाना चाहिए ना आपको नेक्स्ट वीक तक. We will see what is to be done. Next Thursday. There is a direction of the Honorable Supreme Court for expeditious disposal of this case. So I will not give you longer times. It can't, such kind of prayer cannot be entertained.
Day to
We
day,
do not know.
Your Lordship has already taken note of the fact that the Honorable Court has said that it would fix a schedule of hearing, and now they want the matter to be dragged
आपके
here.
हिसाब से डेट नहीं होगा. वैसे भी आपके सीनियर तो आते ही नहीं है. मोस्ट ऑफ द टाइम आप ही बहस करते हैं. You are the senior in this case. You know the case better than your senior.